received what's called a trademark infringement letter.
Don't fold immediately just because someone sends you a piece of paper or they send you an email sometimes and they're threatening you.
My use of the two-word phrase basically can cause consumer confusion.
She didn't think there was actual consumer confusion, so I'm curious to see what she decided to do in this situation. I remember when I launched my law firm about a decade ago, and before I started offering trademark services to other people, I had to learn how to do it myself. And this is as an actual business owner, right? I've been launching businesses and doing my thing since I was literally 16 years old, and I have had to go to bat when it comes to protecting my own trademarks for my businesses. So I'm very passionate about this, besides the fact that we literally do hundreds of these every year. But in any case, as a trademark attorney today, I wanted to give you a trademark attorney's reaction to someone who's having an issue with their trademark and they received a cease and desist. So without further ado, let's jump into it.
Hi everybody, welcome back to Sunshine Soap and Candle Company. Today's video is a very off-brand video for me, but after much thinking, I thought that sharing my experience and my story about something that recently happened would be very beneficial for small businesses or anybody like you and me. So I took a little informal poll on my Patreon campaign last week and asked them if they wanted to hear about this story, and the response was an overwhelming yes. Before we get started, I just wanted to let you know that I'm not very good at video blogging. My strength lies in the video tutorials that I share with you every week, so I apologize if this seems a little disjointed. I've taken some notes and I'm going to do my best to explain my story, and I also just wanted to let you know that I'm no expert in the area that I'm going to be talking about. I'm simply just sharing my experience with you so that you can maybe learn something from what happened.
Oh, she seems so nice. We represent businesses, small to large, all over the United States. So the description on the YouTube channel is this is Sunshine Soap and Candle Company, a Northern California-based company that prides itself on producing high-quality homemade candles, cosmetics. The owner, Corey, so this must be Corey, started Sunshine Soap and Candle to share her unique hand-poured, handcrafted products with others. All right, let's see what's going on.
So a few months ago, I received what's called a trademark infringement letter from an attorney in another state. I'm in the state of California, and this came from out of state from an attorney's office, and I was super confused when I received it. So I wanted to just go over a few things before I talk about the letter. I wanted to just give you the official definition of what a trademark is, because I was under a different impression before I received this letter, and going through this process has taught me a lot. So basically, a trademark can be basically anything. It can be any word, phrase, symbol, design, or a combination of these things that identifies your goods or services.
Perfectly stated, as well as for a trademark. So you can have, of course, the common ones, the word, right? Your name of your business, even your name as an individual if you're conducting business under that name. So the name, the logo, those are the most common, but you also can trademark sounds and smells, right? What's my favorite? Play-Doh. Play-Doh is a trademark smell. The color Tiffany blue, that is a trademarked color.
It's how customers recognize you in the marketplace and distinguish you from your competitors. So this is all according to the United States Patent and Trademark Office, which has been a very useful website for me. So I'll go ahead and link that website in the description box below so you can take a look at it. And basically, the trademark infringement is the unauthorized use of a trademark or service mark on or in connection with goods and or services in a manner that is likely to cause confusion, deception, or mistake about the source of the goods and or services. So the trademark infringement itself had to do with my use of a two-word phrase on an under-eye cream night cream.
All right, making some notes. So it's an under-eye night cream, aka she's selling an actual product. So you can connect your trademark, right? Let's pretend the name of even just the business, right? The name of a product, the name of the business as an entirety. So aka it's the source identifier. You don't know it's Pepsi, right? Unless it says Pepsi on it. Now, one thing I want to clarify, she goes, well, I'm in California. So you gain what are called common law trademark rights just by using your trademark. So some people, they'll come to me and they'll be like, I don't want to launch my thing just yet because I don't want people to know my super awesome trademark, right? And I go, actually, it's the opposite. Under trademark law, you start gaining rights as soon as you start using your trademark in association with your goods or services. And sometimes it becomes a matter of who started using it first, if there's competition or a conflict, I should say, of the same trademark. But anyway, so she's based in California, but typically if we are going to go and register a trademark, we want to do it at the federal level because it gives you protection of your trademark throughout the entirety of the United States, right? If you're needing legal help, feel free to reach out to Delgado Entertainment Law, which is my firm. We offer free case evaluations with our case manager. So just meaning you don't have to make any kind of commitment. We'll just see how we can help you. Feel free to call us. You can text, you can email. We look forward to hearing from you.
In layman's terms, my use of the two-word phrase basically can cause consumer confusion. So if somebody's going to buy it online, they might confuse my product with this other product and accidentally buy mine. And also it tarnishes, my use of the two-word phrase tarnishes his client's trademark.
Okay.
So immediately
Allegedly.
after getting the letter, I looked up this other company to see what the product was. And then I got even more confused because I felt like there was no way I could be causing customer or consumer confusion or tarnishing the trademark with my use of the two-word phrase. However, when you look at the actual trademark, which is the next thing that I did, there is a little piece under the trademark. It encompasses a whole paragraph of items. But there was a little piece in their trademark that talks about skincare preparations and also, see if I have it, preparations and substances for the treatment of damaged skin and tissue. So even though our products are completely different, that two little line phrase in their trademark or what it encompasses, I think is why they thought that there could have been some sort of customer confusion or consumer confusion, even though our products are nothing alike, they don't look alike. They're not even named the same thing. It really is just that two-word phrase that they have a trademark on.
That's interesting. Okay, we don't have the actual words here, right? We don't have the actual trademarks to compare, but what I can say is that typically consumer confusion, a part of the analysis is that are consumers actually confused? So it sounds like she had a product in commerce, meaning she had it on the internet, people could go buy it, and then this other business owner comes and says, well, your product is going to confuse customers as to my product. Now, part of the analysis is literally, well, has there actually been consumer confusion? Do you have emails from people saying, I'm confused? Or people buying the other product and be like, oh my gosh, I thought it was John's. So that's a part of the analysis. But there's also something called the DuPont Factors. And so under case law, basically we go and we literally compare the similarity of the words themselves, the similarity of the products themselves. There's multiple things that we look at rather than someone just saying, well, I have the registration for this product, which again, I'm assuming at this point, right? Because obviously anyone can hire an attorney to send you a letter and be like, I own it, you stop using yours. Okay, do you actually have the trademark registration? So that's number one, we're gonna assume this person does, but quite frankly, never assume anything. But then what our business owner is sharing here is that she didn't think there was actual consumer confusion. So I'm curious to see what she decided to do in this situation.
So after reading that, I thought, well, maybe I'll just go ahead and reach out to this attorney and just let them know, hey, no problem. I'll change the name. I'll rebrand everything.
Oh, wow.
I'm not married to the name. No big deal. I had no idea that I was infringing on anybody's trademark.
Oh, she's so nice. She's so nice. Oh my gosh. See, this is why, it's like, get an attorney who's a shark. Well, sometimes you're just a really nice business owner. You need someone, again, I don't have the full context, but what I can say is that sometimes people just go and say stuff. And sometimes those people are literally lawyers. And then you get into this whole ethical gray zone. But if you get a scary letter from a lawyer, if you're not represented by an attorney, right? I would 100% understand someone coming back and just being, oh my gosh, no, I wasn't trying to do anything bad. I'll just do whatever you say. So at least in this situation, we have someone who is not being adversarial. And I will say, I forgot to mention this on the YouTube channel. She has, at least right now, 209,000 subscribers. So amazing for just brand building and basically being a powerhouse.
The more I read the letter, the more I thought, you know what? I really feel like I need some help with this. I don't think I can handle this on my own. And they did ask me to cease and desist, which I had no problem doing, but there was something in the letter that just, the more I read it, the more I thought I probably should retain an attorney and seek some advice on this. And I think it had something to do with, they were basically saying that they were leaving their client an option to sell me a license. for using the name, and that is something that I just didn't want to do, and I was super confused by it. So I went ahead and I interviewed several attorneys in my area, specifically trademark attorneys. And we went ahead and we retained a trademark attorney, which ended up being a very, very good idea.
I guess what I would say is that just don't fold immediately just because someone sends you a piece of paper or they send you an email sometimes and they're threatening you. So love that you got an attorney. Amazing. 2, I'm curious. In the letter, you said that there was an offer to give you a license. So that's called a coexistence agreement. You go, hey, I think that you're infringing on my trademark, but I will allow you to keep using yours. And then you put together a contract saying what those terms are. Often there's going to be a licensing fee that's paid. And for me, I'm like, seems a little suspect, because if you really were so scared about consumer confusion, why are you also in the same letter saying, hey, but I'll let you keep using your trademark for your product, you just pay me money?
So after hiring the attorney, he did a bunch of investigating for me and looked into this other company and looked into any prior trademark infringements or lawsuits or anything that they may have had already, and basically came back to me and said, I don't think that there really is any consumer confusion here. However, it just kind of he validated what I said a little bit ago regarding the skincare preparations part of their trademark and the damaged skin tissue part of their trademark. And he basically said, because this is in here under their trademark, they do and can come after you for this. So really it was kind of a matter of where I wanted to go with it and what I wanted to do. And I had a couple options as far as this was concerned. But the first thing that my attorney did was just reach out to the other attorney, and he basically said, hey, my client is willing to just let go of this and rebrand this and not use the name anymore, and basically kind of indicated to them, how much money I've made on the product and that sort of thing. And there was a series of negotiations that happened after that.
Okay. All right, look. So when it comes to trademark attorneys who are handling the federal trademarks, just for clarity, guys, you don't have to go and get your local counsel, right? So we could be anywhere in the United States. You want to have the best person who can kind of come to bat for you, because here's the thing: as your star continues to increase, so will the targets on your back, and you will have people who are just coming after you just to see if they can squeeze money out of you. So the one thing that I may not have done in this situation, and I typically don't, is to volunteer information, because the client doesn't think there's consumer confusion. The attorney said doesn't think there's consumer confusion. So then why are you participating in negotiations and volunteering information about how much money had been earned? No one is actually entitled to that. They may get it through a lawsuit, but that's like 6 months after they file, and it's called discovery. But that would cost them like $50,000 to get that from you. So just on a strategy standpoint, I'm game when you're like, no, let's be friends and nice and all of that. But equally, if we have a united front here on Team Sunshine Soap and Candle Company, and we go, we don't think there's consumer confusion, quite frankly, one of the things we discuss is to tell the other side to go take a hike. But anyway, let's see what they did.
So basically, based on the response of the other attorney and the other client, after my attorney's initial contact with them, I started to really understand and know that I wasn't going to be getting out of the situation without some sort of payment. So this took several months to resolve, but basically that initial contact was made, and then the other attorney came back. It took a long time to get to this point, weeks to get to this point, but the other attorney came back, and basically they wanted to sell me a license, which I told you earlier in the video that was not something that I wanted to do. I didn't want to purchase a license for it, but basically, because their trademark was not a contestable trademark, they wanted to negotiate with me.
Why isn't it contestable? Again, I hope these are the conversations that this attorney already had with this client, but why isn't it contestable? Just so you know, just because someone has a registration, you can go and cancel it. There are grounds to get someone else's trademark canceled altogether. The red flags that are going up all about this is she's talking about, well, it took several months of negotiating. Why are you negotiating with them? If you don't think that there's any consumer confusion, you don't submit to a bully who just sends you a letter and says, we're going to do X, Y, and Z, and it's always, we're going to sue you, we're going to basically take you to the cleaners in so many words. But so far, what I'm hearing is that they were volunteering information about what her earnings were, none of their business. If you're negotiating with the other side, you're working towards having to pay them something. She didn't want to pay them anything. And then the several months of negotiations means that she was paying usually a couple $1,000s to her attorney every month on top of what she, well, it sounds like likely ended up paying in a licensing fee.
And by negotiating, they wanted me to either turn over all my sales, my numbers of everything that I've made on the product, and or they wanted to resolve the issue with me paying them a lump sum of money, which was a lot. And they also wanted me to, let me read it to you. They wanted me to pay this lump sum of money for the infringement of the client's incontestable mark for the past years, and a 5% licensing fee on all future sales, or a one-time payment of, I'm not going to tell you, but it was a lot, for the non-exclusive future use of the mark on the product. And I'm telling you, when I saw the numbers on there and what they were asking for, my stomach just dropped. I was literally thinking, oh my gosh, this is going to drain my kids' college fund. What am I going to do? And my attorney was super cool about it. And basically he said, we can negotiate this. This is just, the initial demand. And what I'm going to have you do is go ahead and turn in all your profits and losses. And then we'll go from there.
Gotta be honest, it kind of sounds like this attorney doesn't think that there's no consumer confusion. It sounds like he does think that there's a problem, because otherwise, why are you negotiating a license? Because she just said they want a big old lump sum purge payment, and then they want a 5% licensing fee on all of the earnings related to this product moving forward. I've had people tell me before that I'm overly aggressive, but you better believe when I get in these situations and I feel like another business or another attorney is trying to literally take advantage of my client, yeah, you're gonna get overly aggressive.
So I turned in all my profits and losses to my attorney, and he basically indicated to them she's not interested in a license. I never really wanted to do that. I never had any intention of doing that. So he let them know that I was not interested in licensing the name. And then he went ahead and turned in the profits and losses to the other company. After we turned all that in, it took what seemed like an eternity for them to come back with a second demand. And the demand was far lower than the first demand, which started to ease some of my anxiety. And then through a series of negotiations, we came to a settlement. And it recently settled. And although I was super upset to have to pay anything at all, because like I said, I still don't think that I was causing any consumer confusion, although I could see how potentially that could have happened. Although I was super upset to have to pay anything at all out to the company, I am glad that I only had to pay what I paid. And so I was pretty happy with the terms of the settlement. And that being said, there's a couple other things I wanted to talk to with regards to this whole issue.
Let me demystify a trademark cease and desist / demand letter for you. My law firm sends these letters all the time because we have clients who do have trademark registrations. You have to protect your trademarks. You have to enforce your trademarks. And so when we send these letters, typically we go, hey, we believe you are infringing for this basis. And then we give a little list. These are the things that we do need, right? Such as your books. We need profit and loss statements. We need to know where have you advertised using our clients' trademark. But you make all of those requests in good faith. And then if there truly is consumer confusion, the trademarks are substantially the same, you can negotiate a coexistence agreement. The other side, in some instances, does need to stop using the trademark altogether. But if you are actively monitoring the market, so there are all kinds of companies out there, I do it as well, but you do trademark monitoring, which is when something new pops up that is infringing to your trademark, you try to deal with it right away. So it's not going to be someone who's been in the marketplace for a decade and all of a sudden you're popping up and being like, oh yeah, by the way, I need you to pay me everything and give me 5% of everything thereafter. Now, what I will say is that if the product had made very nominal money, I'm not even sure that they should have engaged in negotiations whatsoever because she had to pay something eventually. But if the earnings of the good had been extremely low, And so they go, we think you made millions of dollars on this. And you're like, we really didn't. Sometimes that can help to get someone to go away. So it can be part of negotiations if you are negotiating.
So first of all, I did have the option to contest it. And because I was like pretty confident that I wasn't causing any consumer confusion, there was a part of me that did want to contest it. However, all of that costs a lot of money. Contesting it costs money because you do incur all those attorney fees, and we've already paid the attorney, the retainer fee, and then, any other bills that come up beyond the retainer fee, which is not cheap. And we just kept thinking, if we contest it and we lose, then the terms of the settlement could be so much higher. And so that was kind of a scary thing to be facing. So we ended up going the settlement route just because I wanted to come out of the situation paying as little money as possible. And so we did feel like not going to litigation was probably the best way to handle it, at least for me.
Okay. Let me say, again, I love this business owner. She seems like she's just trying to run her business and like put good products into the world to help people's lives and all that. So I 1000% know two things. It's very common that the person does not want to deal with this. We want to shorten the time horizon of how long someone needs to just carry the weight of this kind of stress. It sucks. But then number two, to keep costs down. The longer it keeps going, the more you have to pay. My general philosophy on this is to keep costs down. And sometimes that means that we do not engage, because as soon as you engage, you are now paying, well, at a minimum, your attorney, right? Now, there are times you gotta go to bat. Sorry, there are times it is time. We gotta litigate, we gotta do all the things, but often there are other alternatives such as settlement. And settlement is all about what both sides basically are unhappy with to make the dispute go away. Now, what I can say is that, it sounds like they did get it settled. It at least is out of her life. That's great. But if I was representing this company, one thing that I would say is I go, look, you have over 200,000 subscribers on YouTube alone. And so as your business continues to scale, part of the business strategy is learning how to handle companies that come along and threaten you. And usually the first couple of times, it's really scary, and people and business owners are more likely to want to settle, just pay to make a situation go away. Now, she did mention about we could have contested it. I don't know if she's referring to maybe filing a petition to cancel, or you can initiate a lawsuit and essentially ask for declaratory relief. So you go, hey, judge, this person is saying this thing. I think they're wrong. I really need you to look at this situation and issue an order saying, for example, there is no consumer confusion. And my last tip would just be that settlement is always an option, even if literally there is litigation. Understanding that, I would have still gone the path of, if you don't think that there's consumer confusion, then that's the position that should have been taken. Because there's a lot of posturing that happens in this realm specifically of someone saying, I think this, I want you to pay me money. And then it's just a gamble. If you send that kind of thing out to 10 different businesses and 50% of them cave and pay you licensing fees, well, great. That's a good business model, right? So to Sunshine Soap and Candle Company, thank you very much for sharing this information. It's so valuable. And hopefully we were all able to learn a little something from this reaction video. Be sure to subscribe. I'm all about helping businesses grow and stay legally protected. I'll see you guys on the next one. I'm Miss Crystal.